Hello everyone, I'm Dwight Mitchell. I'm the founder of Family Preservation Foundation. Welcome to our Child Protection Pro Se Help Kit video series. Today's series is related to working with your attorney. This is, in my humble opinion, this is a very, very important topic. So much so that the PowerPoint is 45 pages. This may be a little bit long, but I think it's very, very important, and it's key, it's critical to you getting your child back and working with either the court-appointed attorney or a private attorney. So many cases are won or lost because of how the attorney approaches the case. Each attorney has their own strategy. It's really up to you to win. It's not your attorney's child that's on the line, it's your child that's on the line. So you need to fully understand everything that's being discussed. Everything must be in writing. We'll talk about that. I think this handout is key because it starts in the very beginning, and you're going to be working with attorney for quite some time. So you really need to find a good attorney that you can work with and work eye to eye with. I hope you enjoy the content and it allows you to better understand your rights and the options that you have while you're involved with CPS. If this is your first time joining and you don't know who I am, after a 22-month battle, I successfully defeated Dakota County Social Services and the state of Minnesota pro se and had my children returned. This is after I had a high-priced, expensive attorney for about 14 months. And I said, well, this isn't working. I understood after doing a lot of reading what should be done, and I decided to proceed with the rest of my case pro se. So although filled with anguish because they had my children for such a long time, it was an education to say the least. And what I'm doing is passing on the benefit of my knowledge, working with attorneys and reading and Google Scholar and case law. So all my lessons learned I will be providing to you. I'll be cross-referencing the Minnesota State Statute as I go along and do this, and tell you where to go to look at case law, look at Google Scholar, and how to help you have a better working relationship with your attorney. Now, having said that, I must say I'm not an attorney. I have to advise you this at the beginning of every single episode that I'm not licensed to practice law, nor am I providing you legal services. This is strictly educational information. I recommend that you do obtain your own attorney if it's possible for you to obtain one, or to obtain one by the court, a court-appointed attorney. This is, as I said, a very, very important unit, and I don't want you to be misguided like I was with my attorney's legal strategy, incompetence, and or greed. It's one of these things that I have my own view of the world, but I'm not going to belabor you with that right now. Suffice it to say, I don't want you to go through the same thing I did. I don't want you to waste a lot of money, even if you're not paying for it. I want you to have a good experience with your public defender, and I want you to, become educated so that you can make an informed decisions as it relates to things that are going to come along on your timeline, and that you're able to get your child back as quickly as possible. It's going to be a lot of hard work, a lot of reading, but I know you can do it because you're fighting for your family. You got to remember, you're doing this pro se, so you're creating your own court filings and acting in a pro se capacity. In almost every state, everything is online and free. You can go to the court's e-filing website. The public has free access to it. You can look at cases similar to your own. You could pull down examples. You could Google for examples. But everything you do is you're doing for yourself. Pro se means for yourself. You're not allowed to go into court and say, well, XYZ or Joe Kibigabugu told me to do this. No, Joe can't tell you to do something. You have to do it for yourself. So you got to submit your own filings. You got to figure it out, and you have to represent yourself. It's all about you and you fighting for your family. So I'm going to first start out by saying whether you're working with a private attorney or a court-appointed attorney, the rules of engagement are the same, and a lot of people think, well, if I get a private attorney, that attorney will work better. That's debatable. There's some public attorneys that take their job very, very seriously, although they are overwhelmed and overworked. You can make the attorney do what you want them to do by just following a number of the things that we're going to discuss today. So, you have to, establish trust between you and your attorney. You have to educate yourself. You have to understand what's going on. Your attorney has to instill confidence in you. If you think your attorney's a klutz, then, get another attorney. Go with your gut sense. If your sixth sense tells you this guy isn't paying attention to me or he's just not getting it, go with that. Don't stay with that person if you don't have confidence that that person is going to help you and be successful with you. Both you and your attorney have to have reasonable expectations. You need to sit down and discuss this. He needs to find out what you're expecting. You need to find out what he's expecting from you. You got to be honest with your attorney. You both need to be honest with each other if this is going to work. Always ask questions and keep asking questions so you understand completely, what the attorney is talking about. And if you don't understand, then ask for an example. Ask for state statutes. Ask for case law. But, like I said, it's your child and your family, so you need to truly understand what's going on in that regard. As it relates to goals, your attorney has some goals after reading your case or reading your case file. He should formulate some goals and should write them out. Ask your attorney, what your goals are. He should be asking you what your goals as the client. Like, what do you want? Of course, your goal is to get your child back. And if the allegations against you are false, then you need to say, my goal is to, prove my innocence. So articulate your goals to the attorney, tell him why, and keep revisiting these goals as the case progresses, 30, 60, 90 days, to see if your goals are being met and if they're realistic. Ask questions to further help you define your goals. Your attorney may be able to help you elaborate on your goals. Like, I'll have ideas sometimes, and I'll tell them to my attorney, and I'll have the concept of what I'm trying to do, but the attorney has to put it in the legal format, or, I like to call it legalese myself, but that's what, the attorney has to do. Whatever you do, do not, and I repeat, do not let your attorney bully you. Your attorney works for you. It's not the other way around. So, you should be working together, and it should be a working partnership and relationship, but don't let the client say, don't let the attorney say, this is what you're going to do, this is what I'm going to say. No, it's not the case. It's the other way around. You are deferring to the attorney because he has years of experience, but he needs to explain it to you. Don't let him bully. You're going to do this because that's what I said. I'm like, oh, no, I'm not. So keep that in mind also as you move forward. Have your attorney define the scope of representation. And when I say the scope, you're in a CHIPS proceeding. Have your attorney explain his understanding and what he is and is not allowed to do and how he's going to represent you. Have him explain, like, if there's an existence of, like, any collateral legal issues that may impact the case. And when I say collateral, if there is criminal proceedings, criminal charges, if there's maltreatment determinations, licensing. If you're a nurse and you're found that your child has been adjudicated CHIPS, you cannot work in the nursing profession. I know one of our members who actually had to leave Minnesota. She got her child back, but she had this determination finding, and she couldn't work in Minnesota as a nurse, so she had to go to another state to continue her profession and take care of her family. Define the scope of what your attorney is willing to do for you. Each one has, limitations. I should say they're, within the confines of the law. You have some attorneys that just won't do something just simply because it's their opinion, they don't like it. So see if you can get that out right away also. Always talk about your appeal. If this doesn't go right for you, what do you need to do to preserve your appeal? And so, granted, the case has just started, but the appeal process is at the end, and what happens is if the attorney doesn't capture everything in the right way or pull in all the evidence, in the first instance, in this first trial, well, then your appeal process goes out the window. So, make sure that's discussed and written down. Put the scope of the representation in writing. I'm going to tell you, put everything in writing. When you're dealing with chips, everything goes in writing. But, what the attorney is going to do, what he's not going to do, how he's going to represent you, what his strategy is, all that needs to go in writing. If an attorney won't put that in writing, then you don't want to work with that attorney, because you don't want somebody flying by the seat of his pants. You want him to know exactly what he's doing and how he's going to apply that to your case. When it comes to managing the attorney and the client expectations, here again, you do have to be honest with each other. You need to make sure that you're telling your attorney the truth and that your attorney is being completely honest with you. You have to understand all your options. If you don't understand all your options, well, there's no way you can make an informed decision. I mean, it's just impossible. Sometimes it's going to be tough to make a decision, and so don't allow your attorney to rush you or to push you or to bully you into making a decision. That's not right for you. If you feel uncomfortable, listen to that sixth sense. There's usually something that's accurate about that sixth sense. Talk to someone who is older, who has more wisdom. Don't talk to your girlfriend. Don't talk to your best friend, because they aren't in chips. You need to either talk to somebody that has experience, talk to your parent, talk to your grandparent, aunt or uncle, talk to clergy, someone who has more wisdom, or someone that has experience dealing with this, not necessarily, a person who's gone through chips, because what they went through might not be what you went through. And plus you got two different social workers and two different judges. But you're just trying to come to an understanding, because ultimately you have to make the decision. The attorney can't make it for you. Your mother can't make it for you, because any decision you make, you're going to have to live with. You got to own up and take responsibility for all of your decisions. To have a truly good working relationship, there should be contact or communication outside the courtroom. If your attorney, say you meet your attorney and you have a court-appointed attorney and you meet him on day one and you don't hear from him for 2 or 3 weeks, that's a red flag right there. That means that attorney's not thinking about you. That attorney is focused on something else. And in order for that attorney to be advocating for you, for it to be a zealous, ethical attorney, your attorney must contact you and should be contacting you between court hearings. It's not every day, but, in that first 30 days, there should be a lot of contact and a lot of correspondence. It's not like you go to the EPC hearing and then you don't talk to your attorney again for like another 60 or 90 days. That's wrong, and you need to cut that off right away. So you need to develop a communication plan, and you need to say to your attorney, we're going to have a check-in call. We're going to have a status meeting every Thursday. I don't like to do them on Fridays, because Friday's the end of the day and people are busy. It could even be any Wednesday. I don't like to do mine on Wednesday or Thursday about 4 o'clock, unless I can't attend. And that way I know what's going on. We're gonna phone each other. There's gonna be email. We're gonna have a conference call, and we're gonna put this communication plan in place. And you must document all your important dates. Put them in your calendar. When's your EPC hearing? When's the admit deny? When all of that. You can't miss any of those. Technically, your attorney should be keeping you apprised of all these important key dates, but you need to be aware of them also. So preparing for court, the first time you go to court, I've been to court many, many times, and while I don't expect people to be dressed in a suit and a tie if you don't have a suit and a tie, I tell everybody, be punctual and wear your Sunday best. Act like you're going to church, because this is something that's very important, and as we all know, that first impression is a lasting impression. If you go into court looking disheveled and shoddy and bummy, that's what the judge is going to see, and the judge is going to believe the social worker right off the bat, because he's going to look at you and he's going to be like, okay, this person doesn't even have enough respect to come to court with a suit, tie, a jacket, a shirt and a tie, or a dress. No hoochie mama dress, but just, a nice Sunday go to church dress. to fight for her children. That means she doesn't really care about this whole proceeding or what's going on. Your demeanor in court, we're all in there. We're mad. I was mad. Everybody in court who had their kill ticket are upset. You got to try and maintain your cool. That's the only way I can describe it. It's hard. It's rough. I went through this range of emotions. I went from shock into disbelief to astonishment to anger to revenge. My emotions went the full gamut. But when you're in court, try and keep it cool. Don't be like looking up or catching an attitude when you don't like what's being said. Try and keep a poker face. That's what I like to say. Just be calm. I hold my hands and I just keep them in front of me. So I'm not gesturing. As you can see, I'm Italian. I talk with my hands all the time. But I try and keep my facial expression and everything as composed as possible. It's not going to help you to get the judge pissed off. It's not going to help you for the judge. For you to be arrogant with the judge or you to be disrespectful, even if you know that the social worker isn't telling the truth. The social worker is making allegations that they have to prove in 60 days. In that first hearing, all they can do is talk, and you talk also. But keep a cool, calm demeanor. Don't let them know what's going on. Your communication in the courtroom, as I said, be respectful. Yes, Your Honor. No, Your Honor. Yes, Your Honor, I understand. No, Your Honor, I don't agree with that, Your Honor. Can you, repeat that or whatever? Just keep in mind that anything that the other side says they have to prove with evidence. If you know they don't have the evidence to prove it, you getting mad and upset, they're lying. That's not going to get you anywhere. You'll get your day and you'll get your say in court. But if you see your children and say they took your kids away and you see your child, of course, you're going to be the loving parent that you are and you want to see your child, but, always, maintain your cool. That's the only way I like to put it. So the one thing that's going to happen if they do remove your child from your care and custody is they're going to have these things that they're going to want you to do like right away. I can't tell you what to do. I can only tell you what I did, and I can only tell you, what I would do. Having to do it all over again, I would do the exact same thing I did the last time, with maybe like one or two added things that I know now. So when you get to this section of the PowerPoint presentation that you have in front of you, you'll notice that I have everything in this section color-coded and in bold. And I'm trying to ensure that you truly understand the significance of what I'm saying here. Here again, it's your decision. I'm just giving you my opinion, like we all have one, and I'm telling you what happened to me, and I'll tell you why. But the court the social worker is required to put together a case plan within 30 days. Do not start a case plan at all unless you have had a trial, which is supposed to be in 60 days, and the judge finds in CPS's favor that your child is in need of protection or services, and the court orders you to comply with the case plan. Do not comply with the case plan before then. Do not let them say, well, if you start the case plan voluntarily, you can get your child back faster. That is an absolute lie. It is not the law. What it does is it shuts off a trigger. And if you start your case plan voluntarily, they do not have to give you that trial in 60 days. I repeat, do not do the case plan. Look at the state statutes. I'm going to be going over them shortly. I'm going to tell you exactly where they are. But please keep that in mind. If your attorney tells you to don't work with them, work it out. No, that attorney is being paid by the other side. That attorney is not working in your best interest. You look at that attorney square in the eye and you say, trial, 60 days, make it happen. Done. I'm not doing any case plan. Now, what you should do is a visitation plan. The only thing you should be doing is a visitation plan. By Minnesota state statutes, they have to allow you to visit your child once or twice a week at a minimum. Don't let them tell you you have to sign all these forms and you got to sign these permission slips and you got to sign slips for the doctor and this and that in order to no, you don't. And if they don't allow you to see your child, you go to court, you file a motion, you give it to the prosecutor and CPS, and you tell them they're violating the Minnesota state statutes. You want your visitation plan immediately. Don't let them say, well, we got to set it up with a supervisor or this. No, that visitation can be at the CPS headquarters. You want to start seeing your child. If you're not seeing that child within the first week, you go to the judge and you tell them, they're not letting me see my child. CPS will try and hold that child hostage against you, saying, well, if you don't sign these other forms, no, that's not the law. And if CPS does that and record that, you take that to the judge and say, Your Honor, this is not the law. You take it to your attorney and saying, this is not the case, and make sure you get it on the record that, they're not allowing you to visit your child. The third thing that you see highlighted in green on this PowerPoint is do not sign any forms whatsoever unless they are related to visitation. Make sure that it's not a blanket form. Don't ever, say, sign this form for visitation. Say, well, fill out the form. Make sure it says for visitation only, and only then do you sign the form. What they will try and do, which is what they tried to do to me, is try to get me to sign a blank form, and they try and get these other parents to sign these blank forms, or they'll have you sign a form that has visitation, medical visits, medical records, school visit, all these other things. Say, no. One form, visitation, make sure you cross everything else out, and it should say, this form is for visitation only. I didn't sign any forms that they gave to me, Review all forms with your attorney if you have an attorney, but they're trying to shove these forms in your face like immediately. On day one, they're asking you to sign forms. I took all the forms and said, hey, I don't know. These are legally binding contracts. I need to go review with my attorney. I'm not signing anything. And so never sign anything that they tell you to sign on the very first day. Even if the judge tells you to sign, say, Your Honor, let me understand. You are forcing me to enter into a contract. Do you know that, Your Honor, that it's null and void if you force me to sign this agreement? The judge is not going to be happy that you said that, but it's the truth. You have to enter into all agreements voluntarily, without coercion, without duress. So if you're like, Your Honor, are you forcing me to sign this against my free will, against duress? And of course, he's going to have to back off and say, no, that's not what I'm saying at all. Because if he says that, he's in a world of trouble. So please keep that in mind. We'll get to the state statute on that later on, but I'm calling that out early, and I've highlighted it early just so you're aware of these things, and talk it over with your attorney also. And if your attorney is telling you to sign forms, say, show me the state statute that says I have to sign any of these forms. They're not there. There is no state statute that says you have to sign forms. One of the forms are going to be for you to reimburse them for all of the monies that they spent while your child was in foster care. To this day, they're still sending me a bill, to try and get the money back. The other 50%, like the federal government only reimburses them 50%. So they're trying to bill me for the other 50%. But see, I never signed the form agreeing to pay them back that money. And I'm just like, I'm not paying you back the money. I said, I didn't agree to it. So you could send the bills to your blue in the face, but I'll never pay you the money because I didn't agree to do that. So something I should keep in mind, the key points, if you do take a case plan or a visitation plan or any of the plans that you agree to do, if you sign the plan, you must fulfill the plan. Like I say, it's a legally binding contract, and they will use this against you if you don't adhere to it. So your case plan goals are measured by indicators of like whether you're growing, getting better, your self-awareness, your ability to change what they perceive as your unsafe behavior. Not that it is unsafe, but what they perceive to be your unsafe behavior. The county and the court want you to experience real change. Not that you're going through the motions and things of that nature. So that's why I tell you to track your own progress, to have a notebook, to make sure you write everything down, and that no one can refute what's going on. And if you have other people that can come in and say that they've noticed a real change in you, it's a measurable change, it's a marked difference, that's always in your favor. So please be aware of that, and self-reflection, look at yourself and say, am I changing? Have I been learning things? Create a record of your changes and your accomplishments, your goals. If you went to some parenting class, keep the certificate in your folder with your findings so you can make a copy and show the judge, Your Honor, I'm changed. I'm going to these parenting classes, and here's the things that I'm doing to change to get this case to close out in the first 90 days, whatever it takes, or the first 60 days, I'm sorry. As I said, document everything, record everything that you can, have your caseworker sign off on things, have the visitation supervisor sign off on things, the doctors, the lab technicians, have a line in your book, have everyone sign off that you are in compliance, because one of the biggest things that they like to throw around is that you're not in compliance, and unless you have this documented, there's no way that you can refute it. Even if you have an attorney, as I said, it's up to you to win your thing. So the attorney might be saying go, but you have to record that you're going. You're giving him ammunition to say that you've gone. Something that is that I'd like to talk about now is called the allocation of authority as it relates to the attorney-client privilege and rule 1.2 subsection A talks about the Minnesota rules of professional conduct between you and your attorney, and it's something that you should be totally familiar with. The text rule in subsection A, C, and D, and it specifically says, a lawyer shall abide by a client's decisions concerning the objectives of representation, and as required by Rule 1.4, shall consult with the client as to all means by which they are to pursue. So I told you earlier I was going to get back to this. So this is a mandate. You're in charge, and the attorney is obligated by the Minnesota rules of professional conduct to do what you tell the attorney to pursue. It's not the other It's not the other way around. So a lawyer may only take action on behalf of their client if they are explicitly authorized to do so, to carry out that representation by the client. And whatever the client tells them to do, the lawyer is obligated and bound to the client's decision, even if it comes to settle a matter. An attorney can't settle a matter on its own. They can't tell you they're doing something on their own. Only you can tell that attorney what to do, and make sure it's in writing. The same thing goes in a criminal case. If you have child protection and a criminal side for spanking a child for malicious prosecutions, they call it in Minnesota, which is this vague, very vague term. But anyway, same thing. The attorney has to do exactly what you tell them to do unless you waive it. So as it relates to decision making, very, very important. The client has the ultimate authority to determine the purpose and the objectives. You say you might not know. Well, it behooves you to know and understand, because you have to make these decisions. You can't rely on your attorney. Well, what do you think? No. The attorney is supposed to explain it to you, and you need to tell the attorney what you think. Now they may be able to give you goals or give you advice, but you have the decision-making power. So where there is a disagreement, and you want to go one way and your counsel wants to go to another, your attorney must try and come to a mutual agreement on a resolution. Failing that, the attorney must do what you say. They must follow your directions. That's even a public defender. And so that's why I tell everybody to make sure you put everything in writing, because if you have it in writing and he doesn't do what you say, you're like, if you're in court and he's saying something that you didn't tell him to say, you could say, hold it, Your Honor, it's not what I asked him to do. Here it is in writing. Here, that's not my decision, not what I want to have done. So see the comments on Rule 120A of the Minnesota Rules of Professional Conduct as it relates to attorney-client representation. So, and what they must do by state statute, by their own rules. Now, there is a rule 1.2.4 that if the client is suffering in a diminished capacity, they're mentally challenged, or they don't understand, and the attorney's focus is on maintaining a normal relationship, because they should be trying to maintain a normal relationship regardless, then the attorney can sort of be guided, but he has to tell the court, Your Honor, I'm having some difficulty. My client fell and hit his head. I'm trying to keep things normal, but I'm having some difficulty. So in a situation of that nature, they do have a little bit of leeway as it relates to diminished capacity. But when a client's capacity is adequate to make a decision, the attorney still must follow the client's decision, unless he's mentally impaired, or for some other reason, the lawyer shall maintain a normal attorney-client relationship. And if the attorney cannot do that, then the attorney needs to go to the judge and explain to the judge why he cannot maintain this relationship, or what's going on. So, even if the client does have a diminished capacity, a lot of times they do have the ability to reach conclusions about matters, especially if it's in their own well-being. So, keep all these things in mind. I have to bring this forward because this series is going to be seen by a lot of people, and I'm not quite sure where you're going to be. Maybe something might come up where you're in a situation where you get hit on the head, and you have diminished capacity. So you should know what rights you have. Substitution. The law does not authorize a lawyer to substitute his or her judgment in place of yours. If the attorney, in their own judgment or opinion, is A, and you want to do B, the attorney cannot substitute their judge. They could say, well, in my judgment or in my opinion. They can convey that to you. Here again, you don't have to take it, and they are not allowed to substitute their judgment in place of yours. It is still your case, and they are still working for you. Now, an attorney may seek a protection order where the lawyer reasonably believes that the client has a diminished capacity. The client is at risk of substantial physical, financial, or some other harm, and that the client can't adequately act on its own interest. Then the attorney has to go to the court, and the court, he has to explain to the judge why, and then you get a chance to have your say in court also, and then the judge will make a decision. But that doesn't happen often, not to my knowledge. I'm not in court every day, but I don't think any of the parents came to me, and we have about 7,000 parents now, and said that this situation happens. I'm covering it because there is a possibility that it can happen, and you should be aware that even if you have a diminished capacity, you still have the ability to A, take care of your child, B, make decisions. And so the bottom line is that if your things aren't going the way you want, or someone thinks that you have a diminished capacity, then you need to go speak with someone else concerning this. So there are a lot of things that go on when you're talking about a client who has diminished capacity, and a lawyer who represents a client with diminished capacity. That's in the handout. It's the American Lawyer Institute has put together a restatement of guidelines on things that they can and cannot do. Please read that section of the handbook. I'm not going to go into a lot of that right now. As I said before, lawyers have to do their due diligence before they try and take over for a client with a diminished capacity. The law does not authorize a lawyer to take protective action against a client because the client is not doing what the lawyer believes is in the client's best interest. That's not what a lawyer is supposed to do. So when a lawyer says, well, I'm going to get an order because you're not doing what I tell you to. Well, he can't do that. And that's against Rule 1.14b, which specifically says that a lawyer cannot go get a protective order against you because you're not doing what he wants you to do. You don't have to. He has to do what you want him to do. So a client who has decision-making, the ability, that the lawyer considers to be ill-advised, okay, the lawyer has done their job. I've told you, it's your decision. I'll do what you tell me to do, and then that's that. So the lawyers are allowed to provide, their own candid assessments to ensure that you thoroughly understand and you want to thoroughly understand what's going on. If you find that you are having communication issues with the lawyer, this is something you need to get on top of right away. If your lawyer says, I'm going to call you, or if you say, I want you to do A and your lawyer does B, or you tell your lawyer to write a letter to the court about this topic, and the lawyer sends you a letter and it's not about what you say, it's about something else, you need to start that. I always tell everybody to avoid all communication issues, put everything in writing from day one. From the very first meeting, bring your pad and notebook, bring it out and say, write it down, and then at the end say, let me play back what I think I heard. And you read back verbatim what the lawyer said and your notes. Do everything in writing through this entire process. You're going to hear me say that again and again. I'm going to sound like a broken record. You're going to be like, I got it, Dwight. Do everything in writing. I'm going to be like, that's right. Do everything in writing, because you need to protect yourself. The only person that's going to take care of you is you. And you need to understand that. And so I found that out the hard way. The only person that took care of me is me, and that's why I have my kids now, And so I'm hoping the same good fortune happens to you also. So if you are having issues with your lawyer, in some circumstances, a lawyer may be justified in delaying transmission to you or getting back to you, or he has to do some research. So don't necessarily take that as a communication issue. Sometimes it takes time for them to get back to you. They should call you or send you an email and saying, hey, I know I told you I'd get back to you today with an answer, but it's proven to be more difficult than it is. Give me a couple more days and I'll get back to you. That's not a communication issue. That's actually a good form of communication. It's something that all lawyers should do. We talked earlier about the appointment of counsel. That's Minnesota State Statute 260C.163. Appointment of counsel for a child and parent. So I went over that. I just want to mention that again, that you are, and I told you later on I would give you the state statute for that when I was talking about it earlier. You do have the right to effective counsel. If your child is over 10, they have the right to effective counsel also. If you cannot afford a counsel, one, will be appointed for you, by the court. There's only one counsel that the court is allowed to make on taxpayer dollars. So in as 260C.163 says, the child, parent, or guardian or custodian has the right to effective assistance of counsel in connection with the proceeding in juvenile court as it provides in this subdivision. So the subdivision is in the handout. I'm not going to go over that in detail, but suffice it to say, you have that right. The court may only appoint one counsel at the public expense for the first court hearing to represent the interests of the parents, guardians, or custodian, unless at any other time during the proceedings and upon petition of a party, the court determines and makes findings that there are extraordinary circumstances and they require that a counsel is appointed. I have that section highlighted in red if you're following along, so you'll see and understand what I'm talking about. Joint representation is our next topic, and joint representation is generally something you shouldn't do. If it's you and your wife, unless you're doing something together, you should each have your own attorney, just to ensure there's no conflict of interest. You can't have joint counsel, but lawyers generally frown upon that. They generally like to have one counsel per party, unless the parents have done something together. So keep that in mind. There are situations where you can't have joint counsel, but it's generally not something you do. Like a lawyer cannot undertake the representation of you as a client where there's going to be continuous litigation or negotiations between you and the wife, or the wife and you, or the wife wants to say, it wasn't me, it was my husband, and there's a separation, meaning if you and your partner are on the same page, in the same line, then that lawyer can represent you both. But if there's two different things, and trust me, the police and the social worker are going to try and do a divide and conquer. They're going to try and pit the two spouses against each other. So, keep that in mind also. But, by law, if there is, or ethics rather, if there is a division, then there shouldn't be a joint representation, and you should each go have your own attorney. So keep that in mind, because this is something that's known as a confidentiality. So it's attorney-client privilege. And so what an attorney says to you, if it's joint custody, what they say to both of you applies to both of you. But if you each have your own separate attorney, what that attorney says to the one, that attorney cannot come and say something to the other person or the other attorney. That's not allowed. So at the outset, the lawyer should decide what's common and what's not common between the parties. If he's considering joint representation as part of the process, and they should inform the two individuals and seek their consent. And if there is a conflict, then the attorney should withdraw. So there's case law on that. It's State versus Page. That's in my document also. And it talks about the right to counsel, which includes the right to use effective sensitive of counsel. So look at that case law so you're aware of that. And talks about establishing the effectiveness of counsel, the effective assistance of counsel, and what constitutes effective representation, and what's considered deficient performance, for the counsel. Like the attorney calls you on the first day and you don't hear from that attorney again for like 30 or 60 days. Well, that's, not effective counsel. And so you can bring that before the court also. So, also, if there's a conflict of interest and an attorney decides to represent you anyway, that is considered a deficiency on the part of the attorney, because they're not supposed to represent you if there is a conflict of interest. And the case law on that is Wood versus Georgia. That's in the PDF handout also. So please look at that. So and I'll read that. A conflict of interest exists if there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibility to another client, a former client, or a third party, or a personal interest of the lawyer. So all of these things create conflicts. So, please keep that in mind also. Look at the case law I have. I do have some case law in there concerning conflicts of interest, when an attorney should decline representation, how an attorney should terminate representation. I'm not going to go over that in detail, but suffice to say, you should read this. A lawyer must, comply with all applicable laws, because they're an officer of the court, so they're not allowed to do things that are illegal. If a lawyer has represented your spouse in one proceeding, they're not allowed to come and represent you in another proceeding. That's considered a conflict of interest also. If you represent both parents and the guardian custodian at only the first hearing, you may continue to represent only one of them in subsequent hearings. So you gotta split it apart. So keep some of these things in mind when it talks about a conflict of interest and what's going on moving forward. Scope of representation. Section 1.2 of the lawyers' rules of representation stated a lawyer may only limit their scope of representation if it's reasonable under the circumstances. And when I say reasonable, a client wants to give you like false information or wants you to lie for them or something of that nature, that is unreasonable and outside of the scope of their representation. So a lawyer must be law-abiding at all times. They're officers of the court, so they're not permitted to do things that are illegal or that would compromise their position with the court or that would put them in jeopardy of losing their license. So please keep all of that in mind. I've given you my lessons learned and some of the things I've uncovered as it relates to working with your attorney. I think that this is very beneficial. I think you should look at this video twice. I think you should read the handout twice and make sure you fully understand everything and make sure you get everything in writing. In closing, I'd like to say it's up to you to win your case, and it's only you working with your attorney successfully that will make that happen. Or in the case you're working pro se, that you understand the limits of what's available. Thank you very much. I hope you enjoyed this session. You got a lot out of it, and look forward to seeing you in the next educational series. Have a great day.